Thanks for being here, everyone. We're here to talk about the ACLU and the fight for LGBT rights, which the two have a long history together. And so I'm going to introduce Susan, and she's going to go through the history a little bit, and we'll talk about it as we go.
Great. Actually, where I was going to start is, for those of you who don't know the American Civil Liberties Union, we were founded in 1920, and we work in 14 different areas, which you can see represented there. And one reason why I love the ACLU as opposed to other organizations is that instead of just representing one group that is precarious, is on precarious ground in terms of their rights and equality, we connect the dots and we represent everybody. And so with Andrew's invitation, what I wanted to start with was to tell you that our LGBT work began in the 1930s, and it began with the First Amendment, because Lillian Herman, who some of you may recognize, wrote a play called The Children's Hour, which was on a theme about lesbianism. And the play was banned in Boston because that was considered, just scurrilous. You couldn't talk about, the possibility of women being lesbians at all. So the ACLU joined the producer in bringing a lawsuit in Boston to try to get the play to be produced. And we lost the lawsuit, I'm sorry to tell you, but it brought a lot of attention to the role of the censor in Boston and the whole idea of trying to not even talk about ideas that were considered just,
And so it was banned for obscenity because...
It was banned for obscenity because lesbianism was mentioned. I don't know if you know the play, but it's about two women who are teachers who are accused by children in the school of being lesbians. And it's never clear in the play whether they actually are. But the play just talks about
just
lesbianism,
the mention, I see.
And the mere mention was enough.
Wow.
So I think it's interesting that the work for equality sort of began about the First Amendment, just as our work for reproductive rights began with representing Margaret Sanger, who was not allowed to publish things on behalf of, she wasn't allowed to publish pamphlets on behalf of Planned Parenthood because that was considered obscene.
I see. So this is how the ACLU gets involved in these fights.
So it's a real theme. That's how we get involved. Right. So. Next, I want to tell you, so I'm sure you're all familiar with what the Supreme Court did in the Obergefell case in 2015, where they said that marriage equality was a constitutional right. So I wanted to tell you is that 43 years before the Supreme Court decision, the ACLU of Minnesota represented these two men, Jack Baker and Michael McConnell, who thought that they should have a right to get married. So I think it was amazing that, at the time, again, we lost. At that point, you had to lose. There was no way to win those cases immediately. There was a lot of groundwork to be done first. But I think it was amazing that, that we were kind of so far ahead of the curve in terms of marriage equality. So the thing I want to tell you, too, and then we can, maybe you want to talk about this a little. So in 1986, the ACLU established a specific LGBT and AIDS project, and my friend Nan Hunter was the founding director. And one thing that I think is very wonderful to reflect on now is that in 1986, there was so much discrimination against people with AIDS and people who were HIV positive. Employers didn't want to hire them. They were really just, being, made pariahs.
And from the White House on down, I mean, there was a across the board sort of condemnation.
Right, and it feels like that seems to me to be non-existent now, just discrimination against people with AIDS and HIV. Do you think that's fair to say?
I think that we've come a long way in terms of getting rid of that ignorance of, just
the
general
ignorance, just the general, prejudice against people with AIDS.
Yeah.
But, so also in 1986, the same year, the Supreme Court decided a terrible case, Bowers versus Hardwick. And this is Michael Hardwick, who you see here, who just wanted to be able to keep his sex life private. So he brought a challenge to Georgia's consensual sodomy law, which said it was a really serious crime. You could be sent to prison for years for engaging in private sex with another person of the same sex. So disappointingly, in 1986, the Justice Byron White, who wrote the Supreme Court's opinion, said, oh, that claim has to be facetious. He said, you can't even take it seriously that's that. So at the time, I had a fellow board member at the ACLU, Tom Stoddard, who was with the Lambda Legal Defense Fund. And he said, maybe it's for the best that the Supreme Court didn't just say, strike down the Georgia law, because now we're going to have to do grassroots organizing, and we're going to have to educate people, and we're going to have to build up, the depth of support here so that we won't have immediate backlash.
Interesting.
So,
and
what do you
in
think?
this case, and in the previous one you mentioned, you said, well, of course we lost. So does that sort of imply that cases can be brought knowing that there's very little chance of winning, but there's a strategic reason to bring them anyway?
I think sometimes that's true. I think that was true in Boston. You know, just the fact that we lost that case and it brought a lot of publicity, it was the right thing to do, to challenge the censor's decision. And I think the censor lost a lot of power, you know, over the publicity around that case. So even if you don't actually win the case, I think you win public awareness and you build a lot. So you know, another thing I want to comment on, so you know, back in the day, you know, even in 1986, I think people tended to associate, especially gay men, with this whole idea of sex and flamboyance and partying and it's Stonewall and it's do you have the right to have the police not invade your bar. So what I think is very telling is that after, you know, the Bowers versus Hardwick, a lot of the work that the ACLU did on behalf of gay men, lesbians, etc., was about the very flamboyant things of wanting to raise children, get married, and join the military. So you know, it turns out that, you know, these were often fairly conservative people.
Yeah.
So here's a story that is not as well known that I thought you might be interested in because you all know about Jim Obergefell and what happened with marriage equality. So here's one of the people who really paved the way for that to happen in terms of building support. This is Martin Gill. Martin Gill lived with his partner, who was a man, in Florida. And he was a very kind person and would often agree to foster children, to take them in if they didn't have any family members who could take care of them so that they wouldn't have to live in an orphanage. So he had done that several times. And then he and his partner were actually about to move from Florida to Georgia when the state agency called them up and said, we have these two little boys that we can't find any place for. There's no family member who's able to take care of them. There's a 4-year-old and a baby, and nobody wants two little, you know, African-American brothers. You know, we can't place them. But we cannot separate them because the 4-year-old has become the parent of the baby. And it was amazing. The 4-year-old knew how to change the baby's diaper. Yeah, he was very protective. So, you know, Martin said, well, you know, I'm sorry, we're about to move to Georgia. And the agency said to him, well, I guess they'll just have to spend Christmas in the orphanage. So Martin and his partner changed all their plans. They took in the two little boys. And for 4 years, nobody could be found to place these little boys with. So Martin and his partner kept, you know, raising the little boys who were just doing wonderfully. You know, they were really flourishing. They felt very comfortable. So in 2006, the parental rights of the little boys were formally terminated, and Martin wanted to adopt the boys because fostering is very temporary. But there was a Florida law that prohibited a same-sex couple from adopting children. He couldn't adopt them just because, you know, because he was gay. And so it took 5 years of litigation, but we won that lawsuit in Florida. And I think that was just, it was so important.
Yeah.
Thank you. And Martin Gill, everybody wants somebody like that for a father. The boys are still doing wonderfully.
And was there any legal basis for, you know, barring same-sex couples from adopting as opposed to, say, a single parent?
Right, right.
I mean, was there any legal basis even offered, or was it just...
Well, I'll tell you, you know, the state was really mumbling. They were saying it was not in the best interest of the child because the children would be discriminated against. But I'll tell you how bad this got. Because Florida realized that they didn't have a leg to stand on, one of the questions that we would ask was, well, if it's not in the best interest of these children to be adopted by Martin Gill, how come you allow Martin Gill to foster them? And they couldn't think of anything. So at one point they said, oh, well, in that case, we better take the children away because he shouldn't be fostering them either.
Right.
Yeah, just the reaction you want.
Yeah,
right?
great. So this is 2010. This is a big victory.
That's 2010, and that was very big.
Yeah.
So on the way to marriage equality, we had Edie Windsor, the absolutely wonderful, incandescent 80-year-old, who probably most of you have heard of Edie. You brought down the Defense of Marriage Act.
Yeah.
And she and her partner, Thea Spire, had what she referred to as a very long engagement. They were engaged for 40 years. Yeah, Jack Baker and Michael McConnell in Minnesota also got married, 43 years later. They were able to get married.
And this case was just essentially reversing the logic of the 1973 case. I mean, this decision.
Not quite altogether, because this was just a case about whether the federal government could prohibit recognition of marriages that were valid in a state. So Edie and Thea lived in New York at a time when New York did not actually allow people to get married in New York, but New York decided under Governor Patterson to recognize valid marriages performed elsewhere. So Edie and Thea got married in Canada, and then they came to New York, and as far as New York was concerned, they were validly married. But very sadly, Thea died, and when she died, Edie was going to have to pay, taxes as if they had never been related at all, hundreds of thousands of dollars in taxes, and would have had to move out of their home. And so that was because the federal government did not consider them to be married. So what she challenged was the federal government saying, nobody can be recognized as married. But it wasn't until Jim Obergefell that the Supreme Court actually said, and I like this little quote here, the petitioners ask for equal dignity in the lies of the law, and the Constitution gives them that right. And again, very sad case. Jim and his partner were married, but Ohio, the state they lived in, would not recognize their marriage, and Jim was not allowed to sign his partner's death certificate. So it was a very sad case.
Yeah. And so this is when the court fully recognizes the right of marriage as a constitutional, firmly grounded in the Constitution.
That's right. And I think getting back to Martin Gill for a minute, one of the things that Justice Kennedy, who writes the majority opinion in this case, says is that one reason why it's very important for two men to be able to get married or two women is they may have children who are dependent on them, and it's going to be better for the children if their parents are married.
It's a good thing we had Gill in place.
I know, isn't that great?
Yeah, and by this point, the ACLU is fighting on behalf of LGBT rights without there necessarily being an obscenity, ban or a specific, First Amendment hook. I mean,
right. That's
so
right.
Is that just because, the organization is now firmly on the side of this issue, and we don't have to worry about a First Amendment hook anymore? Or is there?
Yeah, I think that's right. I think at this point it's just an issue of equality.
Yeah.
But you talk about lost causes. You couldn't have made equality arguments, in earlier decades.
Right.
The courts just would have laughed you out.
Right.
So it's not that we didn't do any work, but if you had told me 30 years ago that we would be winning all these cases today, couldn't have believed it.
On the basis of equality,
it's amazing. On
it's
the basis
amazing.
of equality. So I feel like the founder of the ACLU, Roger Baldwin, used to like to say that no civil liberties battle remains won. But I feel like homophobia is basically dying out. Don't you think the younger generations just have no problem with two men getting married or two women?
It certainly seems old-fashioned.
Do you think?
Yeah. I mean, it's not even a Democrat-Republican issue at this point. It really seems that there are obviously Democrats are more firmly ensconced in anti-homophobia, but Even Republicans find it hard these days, at least on a federal level, to say. Which, again, if you had said that 10 years ago, it would have been shocking.
It would have been amazing, just amazing. But there's still a lot of discrimination, and we're still trying to promote legislation to prohibit discrimination in employment and housing, etc. But that does seem to be getting better. But here's the problem. Here's the last gasp of homophobia in the United States, and it's about religion. So you may have heard of Charlie Craig and David Mullins, who live in Colorado. And when they decided to get married, which they're now allowed to do, they have the right to do that, they went to the Masterpiece Cake Shop and tried to order a wedding cake. And the owner of the Masterpiece Cake Shop delightfully said to them, "You must be kidding. I'd rather bake a cake for two dogs." Oh. And he refused to bake them to sell them a wedding cake. He designed his wedding cakes. And what he claimed was that he had a right because of his religion to refuse to sell them a wedding cake because in his religious view, homosexuality was a sin. So that case is now pending in the Supreme Court. And there are two arguments being made by the Masterpiece Cake Shop. One is that it's the religious right of the owner of the cake shop to refuse to sell them a cake. And he's making a free speech argument, curiously enough. It's come around on the other side.
Right.
He's saying, if I'm going to design a wedding cake, that's like forcing me to speak on an issue with which I don't agree.
Right. Well, and that's why you're right to point out that by no means by saying, it's amazing how far we've come in the courts, is that, to imply that there's no homophobia left.
Right.
There's a huge amount of everyday lived homophobic experience. And there's still much more ground to be made. We don't know how this case will be decided.
Yeah. No, we don't. But here's where you all come in. So there's a great amicus brief, a friend of the court brief filed in the Supreme Court. This case is going to be argued in December 5th, I think it is, next month. And the briefs are piling up of people supporting and opposing on either side. And there's a brief that was just recently filed by dozens of different businesses, including a number of tech people from Airbnb to Amazon to Yelp to Apple, to just saying we cannot live with a law. If the Supreme Court upholds the Masterpiece Cake Shop theory, we can't live with a law that's going to entitle everybody to cross-examine their customers and find out who they are and discriminate against them if they feel like it. What do you think? Could you live with that?
From a business perspective.
From a business perspective. That's right. So I think it's amazing support.
Yeah.
So I actually spoke recently at a Wikimania conference in Montreal, and there were a lot of businesses there that were trying to deal with the question of, well, what do we do as a business? Do we take social positions? Can we rise to a cause? And I would like to say to you all, yes, please. this is our Constitution in the United States. And for all of you to be part of this battle, many people are already, I think is so important.
Yeah. Yeah, and then as we talk about, the homophobia that people continue to experience, there's also the trans rights battle, which is still in the process of being fought.
I think we were just talking about that because some of you may have been here where Caitlyn Jenner was just talking about changes in the Olympics. And that, I think, is still a kind of a cutting-edge issue. I think although a lot of people will now accept the idea that 2 men or 2 women could get married, I think there's still a lot of resistance to the idea of somebody being trans. And so this was a big case that we brought with the ACLU of Virginia. And that's Gavin Grimm, who originally, when we brought the lawsuit, we didn't use his name in the name of the case. It was just called GG versus Gloucester County School Board. And Gavin is trans, he's a boy, and was using the boys' bathroom in the school, and it was no problem. And then the school board announced that that was not possible. Because again, there's a lot of prejudice going on here. How can you have somebody whose birth certificate says he's a girl in the boys' bathroom? So what do you think that panic is all about? Why are people so upset about that, even though they seem to have come along with 2 men can get married?
I don't know. I mean, these things go to kind of feelings of almost moral intuition that people have, and it's very hard to legislate or legally determine someone's basic feeling. I mean, when Byron White says, oh, you must be joking to think of this as equality, that's his personal feeling of fear or revulsion or whatever. That's very hard to sort of legislate out of someone.
Yeah.
But you guys are trying.
And that seems to be, and that's why the election on Tuesday was so fascinating, how Danica Rome, who's trans herself, beat out somebody who was the sponsor of the Virginia, transgender bathroom bill, which I think is just great. It's a sign that maybe people are getting there. But who's not getting there is, it so happens, as you know, we did have this election a year ago. And as Mr. Trump likes to say, elections have consequences. So when we were litigating the Gavin Grimm case, we won in all the courts below. And one of the reasons for that was that there's this statute called Title IX, which prohibits sex discrimination. And under the Obama administration, the Civil Rights Division, as well as the Department of Education, defined discrimination as including not letting people go to the sex-appropriate bathroom. So what does the Trump administration do? They rescind that guidance. So they're now, on the other side of the case, and they've now told schools all over the country, no, that's not, in our opinion, that's not against the law.
I see.
So we are still litigating on behalf of Gavin Grimm.
So, yeah, the fight goes on. We're running low on time here, but I think that's a good message to leave us on, that this is not over.
Yeah.
The fight continues. Do you have one more thing you want to
The last one I just wanted to show you is the transgender ban in the military, which fits the same thing.
Yeah.
And that, again, that's what we're fighting. The fight is certainly not over.
Yeah. Well, what was the quote? That no civil liberties battle remains one?
No civil liberties battle ever remains one.
Yeah. So keep up the fight.
Thank you. We're trying.
Thanks for joining us.
Peoplepower.org. You can help. ACLU.org, peoplepower.org.
Great.
Thank you.
Thank you. Right.